Hi, my name is Joe Bartolomeo. I'm an Oregon workers' compensation lawyer. I have offices in Astoria and in Hillsborough. And in today's video, I'm going to talk about how insurance companies investigate your claim. So let's get started. The insurance company has 60 days from the date it receives your claim to make a decision. And in those 60 days, it can do a lot of different things to investigate the claim. We call the 60-day period the deferred status period. What that means is the claim decision's being deferred or pushed out for 60 days at a maximum for the insurance company to look around and investigate the claim. If you are disabled from your on-the-job injury, and you have a work note or an off-work note from your doctor, you will get disability benefits during this time. For the most part, you don't get insurance medical benefits, although you will have some access to your health care, but you will not get the medical bills paid. There are always exceptions. So in exchange for the 60 days to investigate if you're disabled, you will get your wage replacement. You have to be off work for about 3 days, up to 14 days actually, before you qualify for those benefits. Stated another way, if the insurance company denies your claim within 14 days of you filing it, you will not get wage replacement benefits. So let's talk about the different tools the insurance company will employ to investigate your claim. So every claim that an insurance company investigates is going to involve getting your medical records. But we're not just talking about the medical records that come out of or are generated because of your on-the-job injury. The insurance company is going to also look at getting prior medical records, especially if you have a history of treatment or injury to the same area of the body that you injured at work. This is because Oregon, and it's only in Oregon as far as I know, Oregon workers' comp gives the insurance company the ability to deny a claim if they conclude that the majority of the need for your care is because of some prior injury or prior medical problem. So many times when I get a claims file, I will see that the insurance company is looking for past records. Be aware of that. Also, although it's not actually medical records, the insurance company is also going to look to see if you filed past insurance claims. There's an insurance claim index. It's a database. The insurance company will search by your name, date of birth, social security number, and if you have an auto claim or a prior on-the-job injury claim, it may very well pop up. So they're really looking into your past medical history when requesting medical records. In addition to getting medical records, the insurance company can talk to your doctor and ask your doctor questions about what they think caused your injury, what kind of injury you suffered, whether it's going to take any kind of time to heal, or if it'll heal completely, if you'll have any permanent impairment. The access is pretty broad. Sometimes a nurse case manager is an insurance company nurse that will talk with your doctor and may try to dictate how your treatment is administered or what kind of treatment is prescribed. So they have access to your doctor, they have access to your medical records, they have access to your prior claims. So let's move on to other tools that the insurance company has in its investigation toolbox. The insurance company can take statements. They can take statements from your coworkers. They can take statements from your supervisors, the owner of the company that you work for. They will, in many cases, talk to people who perhaps witnessed your on-the-job injury. This is especially true when the employer expresses some kind of doubt about whether you suffered an on-the-job injury in the first place. We have had workers' compensation claims filed at our law office. It doesn't happen very often. It's not a real dangerous place to work, but it does happen. And one of the first questions that we have gotten is whether we have any doubts about the validity of the claim. If we do, then I suspect that the insurance company is going to investigate or at least be more aggressive and get statements from coworkers about whether there was an injury event, what the injured worker said about whether there was something else going on that caused the medical problem. So be aware of that. Your coworkers could be questioned, your bosses could be questioned, and there will be investigation reports that are available. We get them in the claims file when we appeal a denial for our client. The other kind of statement that an insurance company can get is from you. And the statute requires that you cooperate and give the statement. And if you don't, then your claim can be denied because of it, and you could actually be fined. So also, and this is important, if you're getting time loss because you're disabled from work and you refuse to give a statement, the insurance company could try to stop your time loss payments. So you have to give a statement. The good news is that if you have an attorney or if you hire an attorney, they'll actually be paid by the insurance company to sit through your statement. It doesn't mean that they're working for the insurance company. They're your advocate, but it will not cost you anything to have an attorney present at your statement. So that's the good part. Now, there are a lot of things to talk about when giving a statement. Basically, what I tell my clients is, above all else, be honest, but almost as important, which is part of being honest, don't guess or speculate on any answer that you give. You're only responsible for what you actually know and what you actually remember. The kind of questions you can get will vary. It depends on what kind of investigation is going on. For example, in a hearing loss case, you're going to get lots of questions about what other exposure to noise you may have in your outside of work life. You will have questions about what kind of childhood diseases you experienced or contracted, because those or some of those could be another cause of hearing loss. In a case where maybe the employer doubts that you were actually injured on the job, you will get questions about off-work activities or exactly how the injury happened or who you told about it. So the statement can really vary. But the bottom line is you want to be honest. You don't want to guess. If you don't know, you don't know. If you don't remember, you don't remember. If you can give an estimate, that's great. Make sure they understand that you're giving an estimate. So the statement is a key part of the investigation. And here's another thing. Even after your claim is denied, the Workers' Comp Board has ruled that the insurance company can still get a statement from you. So that's one important tool the insurance company can employ in investigating your claim. So let's move on from there. The independent medical examination, or IME, is a required examination. What I mean by that is the insurance company can require that you show up at an independent medical examination to be examined by a doctor that it chooses. Many lawyers, if you search on YouTube about IMEs or independent medical examinations, many lawyers will say there's nothing independent about these exams and the reports that these doctors write. And I think for the most part that's true. My personal opinion, based on having done this for 30 years, is that there's a small group of doctors that do IMEs that are pretty honest, forthright, and truly objective. There's a very small group of doctors, not actually, they're not that small, but there's another minority group of doctors that will always come in for the insurance company no matter what. And then there's all the rest of them. And I think most of them, all the rest of them, are pretty conservative. I have worked with doctors who do independent medical examinations in their capacity as a treating doctor. What I mean by that is they're treating my client, but they also do independent medical exams, and they will admit to me wholeheartedly that when they're doing independent medical exam work, they are looking at the patient or the claimant with a quote-unquote tough eye. That they just admit it. And the fact of the matter is that they're well compensated for these exams and these reports, and they know that if they write a good report, that the insurance company is going to come back to them. And there are some doctors who make very, very good money doing nothing but independent medical examinations. I have another video that talks about what you should look for, what you should be aware of when you do or show up for an independent medical examination. But this is another key investigation tool that the insurance company has at its disposal when it is investigating your claim. So let's move on to kind of the more miscellaneous area of investigation. In addition to getting your medical records, searching for claim history, talking with your doctors, talking with your coworkers, sending you to a doctor of your choice, sending you to a doctor of their choice, the insurance company has other tools it can employ, and I called this other investigation, but it's probably better called surveillance. We don't see this a lot, but it does happen. If the insurance company really doubts the validity of your claim, it will, at times, hire a private investigator to follow you around and try to catch you on videotape doing something that you're claiming you cannot do. Now, I'm not going to sit here and pretend that nobody has ever tried to defraud an insurance company, but it's, in my view, it happens far less than maybe what the media portrays. We have had some experience with this. In one case in particular, the surveillance video actually helped us prove the claim. Our client was running his own company on his off time, was lifting some heavy objects, probably shouldn't have been doing it, was grimacing and groaning when he was doing it. The insurer tried to use that against my client. The judge looked at it and actually it validated the claim because our client was really struggling with that activity. Should have been following doctor's orders, but he was trying to start his own business, and that's the way it goes. So surveillance is something that's out there. We don't find out about it until the last minute. That is impeachment evidence, which means it's evidence to help the insurance company prove that our client is not being honest, is not representing or testifying honestly, and so there are rules that allow them to hold that up until the hearing. You know, a lot of times when we see it, it's actually pretty boring stuff. It's a video of our client getting into their car, getting out of their car, walking into their grocery store, walking out. There's really not a whole lot to it. But be aware that it's a possibility, and it's another reason why when you're talking in an exam to an independent medical examiner or even your own doctor, or filling out forms, you have to be upfront and honest about what kind of injury you suffered, how it's limiting you in your everyday activities. So that's the last of the investigation tools. Now, what happens after the insurance company has done its investigation, it's going to make a decision on whether to accept or deny your claim. If the claim is accepted, you'll get a notice of acceptance, and in that letter telling you your claim is accepted, the insurance company is going to tell you what medical problem you have or what medical problem it is accepting responsibility to provide benefits for. In other words, what is it going to cover? And that can be a big deal. If you have a torn ligament or tendon in your knee, but the insurance company only covers a strain, then that could be a big deal. So you have the ability to ask the insurance company in writing to change or add the tear as part of your claim. We call those omitted medical condition claims, and there's information on our website about that if you have more questions. If the claim is denied, you have 60 days from the date of the denial to appeal the claim by requesting a hearing. 60 days starts from the date on the letter of your denied claim notice. So that's the ultimate outcome of the claim investigation. There's going to be a decision one way or another. Even if the claim is accepted, you need to be aware of what actually is being covered. I hope this information is helpful. If you have other questions, we have a free downloadable Navigating the Oregon Workers' Compensation Maze. It's a consumer guide. It's an ebook. You can get it off the website. There is no obligation. We do not give out any information. Go ahead and check that out on the website. We have articles on the website that give information about other issues that people commonly face on their Oregon workers' compensation claim. You can contact us on the website. You can give us a call. If we're not able to help you, we can point you in the right direction or find somebody who can help you. Thank you so much for watching this video. I hope it helps. Take care.